A very precise and exact drafting of general terms is key for business people. But at the end of the day, why to draft general terms? Because when you have a business, you have always the same kind of operation and you can rule appropriately this business through general terms. That means that you have not to renegotiate each time this clause with your counterparty. What says the law on this? First, I will analyze with you the different clauses which can be met in general terms. Second, when are these clauses binding for the counterparty? And three, the new Belgian law on B2B unfair terms. It is difficult to analyze in 1 or 2 minutes the content of the general terms you can find in all the contracts. But I will give you the main clause. First clause, which is very frequent, it's an exemption or limitation of liability clause. For instance, the enterprise says that they are not liable for indirect or unforeseeable damage. That's a limitation of liability clause. You have also a penalty clause. Penalty clause is a clause where you foresee that in case of late payment, the client must pay, for instance, 10% penalty on the top of the main sum. Third clause, which is very frequent, law applicable. If you have a business between a Chinese and a Belgian company, the Belgian company will foresee in the application of the Belgian law. Fourth clause, the clause of jurisdiction. That means that you will say, yes, if I sell goods also abroad in Italy, the Belgian court will remain competent because it's the place of my seat. When are the general terms binding for the counterparty? They are binding if the counterparty knows the clause, and secondly, the counterparty must accept the clause. That means that you have to make, as entrepreneur, the clause available for the counterparty, must have the opportunity to read this clause, and he accepts it when he can sign it, or if he does not expressly sign the clause. If there is silence, let's say 1 month after receiving the clause, the case law considers that he has accepted the clause. Thus, he knows he accepted it. What in digital transaction? In digital transaction, the clause must be available for the user or for the client through an hyperlink. Does that mean that he has the opportunity to read them? And secondly, he has to accept them. And accepting when you click I agree at the end of the clause. Since 4 April 2019, Belgium has a new law on unfair contract terms in the B2B relation. What is an unfair contract term? It's a term which creates a disequilibrium between both parties. I will only give you 2 examples, but it is very important in the practice. First, if you say in your contract, I can determine and define all the clauses of the contract, all the content of the contract as I want. This clause is null because you give no say to your counterparty. Another clause, which is also very delicate, is the clause when you say that you limit your liability to, let's say, 500 euro, and the price of the contract is 1 million euro. Thus, in this case, the clause will also be considered as null and void. Pay attention because it's a very unsecure law, and it is important to be sure that your clauses are in conformity with this law. From what I just exposed, you can conclude that general terms are key for business people. I want to draw your attention on the new law of 4 April 2019 and advise you to contact a lawyer to revise your own general terms to be sure that they are in conformity with this new law. If you want more explanation concerning this new law and the practical implication, I advise you to visit our website phillippelaw.eu.